Judiciary Committee will come to order. Our first order of business today is to open the hearing on Senate Concurrent Resolution 1618, proposing a constitutional amendment that provides for legislative authority to revoke or suspend rules and regulations adopted by executive branch agencies and officials. And we will ask for a bill brief. I was looking at the bar over there. A bill brief from the reviser, Mr. Thompson. I'm sorry, Ms. Moyer.
Thank you, Madam Chair, members of the committee. I'm Jenna Moyer with the Reviser Statutes Office, and I staff the Rules and Regulations Committee, which is why you get to hear from me today. And the bill brief is for Senate Concurrent Resolution 1618. It would add a section to Article 1 of the Constitution relating to legislative oversight of administrative rules and regulations. The current law, as part of the Rules and Regulations Filing Act, 77-436 currently requires the Joint Committee on Administrative Rules and Regulations to review all proposed rules and regulations during their public comment period. And after each meeting, that Joint Committee issues a report to the Legislature with any comments or concerns about the proposed rules and regulations that it has reviewed. The committee may introduce legislation in response to the proposed rules and regulations, but the committee cannot require any changes to or reject any proposed rules and regulations. And that's where the concurrent resolution would come in. This would add a section 17 to Article 1 of the Constitution of Kansas to provide that when the legislature has authorized administrative regulatory authority, the legislature would then have the authority to revoke or suspend any rules or regulations adopted under such authority or a portion thereof with a majority vote by both chambers. And such revocation or suspension would not require the governor's signature to go into effect. And the concurrent resolution goes on to have the explanatory statement that would go to the voters. And as with all concurrent resolutions proposing amendments to the Constitution, the resolution must be adopted by a 2/3 vote in each chamber in order to be presented to the electorate for approval. If this were adopted by that constitutional majority in both chambers, it would then be submitted to the electors at the state general election in November 2022. And I will be happy to answer any of the committee's questions.
Thank you. Committee, questions for the reviser? Seeing none, then, we will need to limit the time for testimony today. We do have a lot on our agenda, so we are going to ask that our conferees limit their testimony to 6 minutes each, and I'll be running a timer and give a 1-minute warning. So for our first proponent in-person conferee, it is my honor to introduce to the committee someone very familiar to the committee, but invite him to the podium, Mr. Derek Schmidt, Kansas Attorney General, State of Kansas, on behalf of the Office of the Attorney General. Welcome to Committee, General.
Thank you very much, Senator Chairman Warren and members of the committee. It's good to be back. I think this is the first time I've appeared in front of you this session. You have my written testimony. Let me just kind of give you in a 6-minute window here kind of the concept and the why, and then I'll be glad to answer whatever questions at the appropriate time. So history lesson is relevant here for all of us. Until the 1930s with the New Deal, there really wasn't this thing we now are so familiar with called the administrative state, federal agencies that did all kinds of things. Some would call it a fourth branch of government, if you want, in modern parlance, whatever you think of that. That was a relatively new concept back then, at least the scale of it. And so perhaps unsurprisingly, starting in the 1930s, Congress began exercising a power in various statutes that we've come to call a legislative veto. And essentially the concept's pretty straightforward. When Congress passed a law, the legislative branch passed a law and delegated to these agencies rulemaking authority, which, we always talk in kind of the inside baseball down in the weeds stuff in this building, but at the end of the day, it really is a lawmaking power. I mean, there's legal limits on that delegation, but it is the power to make a rule that people or affected entities must follow, or there is a consequence. The law can be enforced, or there's a penalty or fine or whatever. That is a lawmaking function. It's part of the legislative power, even though our courts would probably articulate that a little bit differently. Congress tried to keep a rein on this, and in a whole bunch of statutes, I think I cited it in the testimony, if not, we have it. It was a fairly common thing that there were these ad hoc legislative vetoes. Well, we'll let this agency do this, but we're going to retain the power to say, no, you can't, by congressional-only action. A lot of states started doing the same thing as the state administrative apparatus grew, and the legislative veto was a very common tool in states and federal law until 1983. And in 1983, the ability of the legislature to do this, to delegate legislative power or power that has a legislative effect, but still retain the ability to reject individual agency uses of it, as opposed to just going back and amending the underlying statute that delegated the power in the first place. That case goes all the way to the U.S. Supreme Court, and in INS versus Chadha, the Supreme Court says can't do it. And the reason you can't do it is the federal Constitution says there's only, really what you're doing is changing the law, because an administrative reg has the force and effect of law for its purposes. And to enact a law, Congress has to present to the executive presentment of a bill. You do it by bill, so you can't do it. After INS v. Chadha was announced, then there were lots of challenges to these state legislative veto provisions in lots of states around the country, challenging them on the same theory. Most state courts followed the U.S. Supreme Court, and in the context of their state government structure, said you can't do a legislative veto. There was at least one exception. Idaho's survived judicial scrutiny, and they still have on the books today the same legislative veto authority they had before Chadha. But most state courts struck them down. And ours was no exception. In Stafford versus House of Representatives, the Kansas Supreme Court struck it down and said you can't do a legislative veto. We actually had one in statute in Kansas before that, maybe more than one. Can't do it. The response to that, legislatures in many states responded. In some states, they put on a ballot for their people to decide, you want to have a legislative veto? And voters said, yeah, we want to reenact one. And they have in some states. So Connecticut has one today. New Jersey has one today. Actually, I'm not sure about Connecticut. New Jersey has one today. Iowa has one today. I think Connecticut. I can double check on that. Because the voters said, yeah, we want to do this. Because you can do it. You just got to change the constitutional structure to allow it. Kansas has never gone down that road. Instead, we took a different path and set up our current system of review of regulations, which includes a review by the Attorney General's office solely for legality. We don't look at wisdom. We don't look at compliance with legislative intent. We just look at whether the law actually allows the reg. And so that's how I got interested in this. We've been doing this now for 11 plus years, and sometimes you'd look at this stuff and you'd say, well, I don't think that's really what was intended, but there's no authority to reject it. You guys don't have the authority to reject it because of the Stafford case. In your Rules and Regs Committee, at the end of the day, you can raise Cain and put a strongly worded letter in the comment file, but you can't actually say no. This is permissive, and should it go on the ballot and the voters adopt it, it would allow you then, not require, but allow you to enact by statute a legislative veto mechanism. And that's what this is. I think it's good policy because at the end of the day, regardless of who's in my job, your job, anybody else's job, I think the legislative power, the buck ought to stop with you guys. And it cuts both ways. Your intent ought to be consistent with what the agencies do, but at the same time, you all ought to be accountable for what the agencies do. You shouldn't be able to delegate to the agency, oh, we can't do that because the AG's office wrote the regs wrong or whatever. Not that you'd ever say it that way. So I just think it's basic good government. That's the spirit in which it's brought. I'd be glad to stand for questions. I'm sure I'm at 6 minutes.
You're fine, General. Committee, out of respect for the General's time, we're going to go ahead and entertain any questions at this time so he can get back to the business he has across the street. So yes, do we have any questions yes, Senator Thompson.
Thank you, Madam Chair. Thank you, Mr. General, for being here. It seems to me like in the light of everything that's happened in the last 2 years, this would take a lot of the burden off of your office and place it back into the legislature where I think it belongs, particularly with regards to some of the mandates issued by KDHE and others. And we'll just welcome your thoughts on that.
Appreciate it, Senator Thompson. I mean, the answer is, I'll give you the lawyer's answer, maybe. And the reason I say it that way, this amendment, you have to do the amendment in order to get to the ability of this body to set up a legislative veto mechanism. Right now, you are barred from doing this because of our constitutional structure as interpreted in the Stafford case. Should you propose this, should the voters say, yes, we think that makes sense, then you're going to be back here, or whoever's here at the time is going to be back here having a discussion. All right, we've got the authority. Do we want to set up a legislative veto? And if so, I think there are going to be a lot of questions that you'll have to wrestle with in that implementing legislation. For example, I could imagine that there might be some subject matter that as a matter of policy you decide, even though we could exercise a legislative veto, we elect not to because for whatever reason the consequences may not be prudent. Might throw us out of compliance with federal law. You know, those are all kinds of things you all are going to have to decide, but you don't even get to decide that unless the Constitution permits you to have the tool. So to your point, you know, whether this would apply in circumstances like you mentioned or otherwise would be determined by a subsequent legislature if the voters authorize you to go there.
Good. Thank you. Thank you, Madam Chair.
Committee, other questions? Thank you for your testimony. I have a brief question for you. Maybe it's not brief. We often heard about these last 2 years in particular, there was a lot of decisions made by executive branch agencies and things. And we also were hearing a lot of, and there were a lot of executive orders that were put into place. Would you be able to talk about for a minute or two about whether we could incorporate executive orders from the executive branch into this amendment, if it were the will of this committee to kind of take that on as well?
Yeah, Senator, we talked about that when we drafted this last year. Obviously, there are some sort of unique dynamics that were pandemic driven, and you know, we elected to, I think, largely avoid those in this drafting because that's not what spurred us here. It's a policy choice. You could do it if you wanted to. I think, you know, I would direct your attention to some language, and you can, you know, interpret it as you will. If you look at lines 16 and 17 of the draft, this would permit a legislative veto to be adopted as to rules and regulations that have the force and effect of law. Force and effect of law, I think, are the operative words. So, you know, it's a policy choice. What action that has the force and effect of law you wish to be able to exercise a legislative veto over. So if you wanted to expressly add some type of other instrument, whether it's an executive order, you could do that. It's a policy choice.
You don't see a problem with the policy being in conflict with what's already in the SCR then?
No, I don't, Senator. I just, you know, it's a slightly different issue. They're related, there's no question, and it's appropriate here if that's the choice. I chose not to go there, but you all may want to at this point. It's a year later after we, you know, introduced this in the first instance, so.
Great, thank you. Committee, other questions? Seeing none then, again, thank you, General, for your time today and your testimony on this very important issue. I think we've all been frustrated for quite some time about rules and regs and their promulgation and enactment, and I'm chairman of that committee, so it's an issue that I've been hearing a lot about as well. So thank you for your time today.
Thank you, Senator. Thank you, committee.
Thank you. Committee, then we will invite our next proponent conferee, Eric Stafford, Vice President of Government Affairs, Kansas Chamber of Commerce. Welcome back to committee. Please introduce yourself.
Thank you, Madam Chair and committee members. Good morning. Eric Stafford, Vice President of Government Affairs with the Kansas Chamber, here to speak in support of SCR 1618. I'll speak in our written testimony. I comment about a bill that was passed in 2018, and the effort is the same, or was the same, with that legislation by giving the legislature more oversight. It was based off Wisconsin's piece of policy known as the REINS Act, or regulations from the executive in need of scrutiny, and that policy in Wisconsin gives the legislature the ability to vote to revoke or not approve rules and regs being pushed by the executive branch and state agencies. And in addition to the legislative oversight, it also required economic impact statements from state agencies to talk to interested parties or affected parties to say, you know, how would this impact you? What are the potential costs to business and industry or anybody who's impacted by the specific rules that are being proposed, whether it's environmental rules or other rules dealing that could potentially impact school districts, so public and private. when we testified on the bill on the House side, we didn't have a position on the base bill, but we presented an amendment to the committee. And in working with the reviser, actually our ally that we worked closest with through that whole process was Representative Carmichael. He saw what we were attempting to bring together as, yeah, we want to ensure that the governor's office and executive branch doesn't have unlimited power to, pursue policies through the administrative state and rules and regs process. But in the drafting of the amendment with the revisor's office, Gordon Self came in and said, hey, because of this Supreme Court case that's out there in Kansas from, I think, the 70s or 80s, we can't give the legislature the ability to approve or not approve regulations. So we could only focus on the economic impact statement in the amendment that ended up passing and getting signed into law by Governor Collier. But it was a step in the right direction. However, I'll speak recently, fast forward from 2018, where we testified last November against several regulations that were being proposed by the Department of Labor dealing with workers' compensation that, in our view and our attorney's view, just flat out conflict with state policy established by the legislature in the work comp arena. The Joint Committee on Rules and Regulations held hearings in November. We testified in opposition to them. Sentiment from the committee was, we don't approve of this, but there's nothing that we can do to stop you, really. And so this constitutional amendment is extremely important for that purpose. No matter who the administration is, Republican or Democrat, it provides another level of checks and balances to ensure that agencies aren't getting out of their line with the rule and reg authority that the legislature is granting them to implement the laws that you all pass. But in addition to that oversight, the economic impact statements, while intended to be good, basically every box that was checked on the work comp regs, they have to go through the budget director process. The budget director is responsible for overseeing the economic impact analysis from the agency and making sure that they're effective. But those work comp regs, nobody reached out to industry on the economic impact analysis. What was the methodology used to determine the economic impact analysis? Every answer on those forms for all 6 regulations were not applicable. So it's clear they're literally checking boxes to say there's no economic impact, but there clearly is, because one, there's notification requirements in those regs that were proposed last November that falls on every carrier and every employer to notify for all 45,000 cases that happen per year in the state of Kansas. There is going to be a cost to the work comp system for these regulations, but those economic impact statements were not fully completed. So the intent of what we tried to pursue in 2018, I think, is good. I think it gives good oversight and additional steps for state agencies to follow, but they're just not fully following it. But that's where this constitutional amendment comes in and fills that void and returns the power back to you, as you said, Senator Thompson, to ensure that the legislative and executive branches still maintain the power to hold each other accountable. So strongly support this constitutional amendment. It's actually up on the House floor today, their version. So we'll be bouncing back and forth to watch that debate and watch this hearing. Yeah, we'd appreciate your support and happy to answer any questions at the appropriate time.
Thank you, Mr. Stafford. Committee, we will hold questions until we hear from all the proponent conferees. We next will invite Elizabeth Patton, Kansas State Director, Americans for Prosperity, to the podium. Please introduce yourself and welcome back to committee.
Thank you. I've been following Eric in a couple committees lately, and I keep having to move the mic pretty considerably down. No, thank you for having me in committee. My name is Elizabeth Patton. I am the State Director for Americans for Prosperity, Kansas. I appreciate the opportunity to testify before you today. We at Americans for Prosperity believe we strive to create an economy that works for everyone, where people can succeed and live meaningful lives. And so we work at advocating strongly for the proper role of government. We believe that government has a role in creating fair and equally applied rules that foster an opportunity-rich environment that for all people, but also protects against significant public harms. However, we do believe that role should be limited, and it's critical that they are not onerous or unnecessary. We also believe that lawmakers, elected lawmakers, should retain their proper role in developing and finalizing laws that include clear and unambiguous guidance. So, I won't get into the history of it. The Attorney General did a great job of explaining all of that. But all levels of government, unfortunately, especially this body, in our opinion, have gradually given broad authority to regulatory agencies, not only to carry out the law, but also to create it. So in our opinion, this has created an imbalance of power, and the executive agencies can create and enforce laws on their own in a way that allows Kansans to have they lack the appropriate mechanisms and accountability. So we believe that that needs to be remedied immediately. In our opinion, this is ending up with public policy that we don't want or need, and it was ultimately created without representation. So in our opinion, in order to restore those checks and balances, we believe that this constitutional amendment is essential. We have tried over the years to put statutory remedies in place, and as previous conferees have indicated, at the end of the day, it has been determined that this has to be the next step. It's important to note that there, of course, is a distinction between regulations that support a legitimate government function and red tape. But I think that we are missing the mark as a state in that because of the imbalance of power that currently exists. Just between, I believe, 1997 to 2015, the regulatory burden on Kansans increased by over 72%. And we think that as that trajectory likely increases, we want to make sure that the legislature retains their authority to make sure they have the proper oversight over that. Over regulations. Wanted to also note that in other states who have done similar things, they have also actually experienced resounding economic success in relating to their budgetary considerations. And we see that this has not only ramifications for individuals, for small businesses, for large businesses, but also for the state and for their fiscal health overall. So we believe the successful passage of this legislation opens a path to significantly reduce red tape and allows the legislature to restore a balance of power as it was originally intended in the Kansas Constitution. Thank you, and I'd be happy to stand for questions at the appropriate time.
Thank you. Committee, then we will next hear from Randy Stuckey, Senior Vice President of Government Affairs and General Counsel on behalf of the Kansas Grain and Feed Association, Kansas Agribusiness Retailers Association, and Renew Kansas Biofuels Association. Please introduce yourself and welcome back to committee.
Thank you, Madam Chair. Yes, Randy Stuckey, Senior Vice President, General Counsel for the 3 different associations. And they're a mouthful, but broadly, we represent agribusiness in the state of Kansas. Our members aren't farmers, but we do business both in the front end and back end with ag producers in the state of Kansas. And for better or worse, we do operate in a highly regulated industry, both state and federal, so this falls right within our area of concern. You know, high property taxes, and then the regulatory community in Kansas is where one of our biggest issues this, not just this session, but in recent years. And I will say that I appreciate the Attorney General's presentation on the issue. I want to make clear that this is not the issue of the day. This isn't in response to anything that's happened recently for outside of the regulatory issues, you know, for COVID or what have you. This is an ongoing issue because we exist in a highly regulated industry for decades now, and that's fine. We're fine with reasonable regulations. It's if those regulations are thought to be unreasonable, overly costly, or beyond the scope of the legislative intent. That's where we need to have the authority remain in the legislative body, that which is most directly representative, answerable to the people. And I think that point's been made a couple times this morning. That's where we were 100 years ago. It's where we need to be today, because and another thing, it's not a partisan issue either. You know, we just had a Republican governor. We will have a Republican administration and executive branch likely in the future. We have had issues with both branches, both parties in the regulatory community. So for those reasons, we appreciate reasonable regulations. This needs to happen, and it may not lend itself to a fuller conversation this morning, but I want to make myself available to have that fuller conversation on this very important issue outside of this hearing, looking forward. So with that, I would just stand for any questions.
Thank you. Committee, we will next then invite, are there any other proponent conferees in the committee meeting room or online? Seeing none, then, committee, before we entertain questions, want to also direct your attention to your committee folder. We do have proponent written-only testimony. Might not yet be a hard copy in your folder, but it is available electronically online from James Franco, President, Kansas Policy Institute, Dean Clark, Director of Stock Growers Division, Kansas Livestock Association, Alex Orell, Senior Vice President, Government Relations, Kansas Bankers Association, and Shahira Stafford, Stafford Public Affairs, LLC, on behalf of the Kansas Cooperative Council. So with that, committee, we will open it up for questions, and we do still have Mr. Attorney General Derek Schmidt still here with us if there are any questions for him as well. Yes, Senator Gossage.
Thank you, Madam Chair, and I wasn't sure if he was going to be able to stay, but I would have a question for the Attorney General.
Sure, we'll invite the Attorney General back to the podium. Thank you.
Thank you for bringing this to us. It's quite a simple resolution, and you were stating that other states have done something like this. Have they all done a 2/3 majority?
Senator, I don't know the mechanisms in other states for amending their respective state constitutions. I think a 2/3 is the traditional manner, but they all would have followed whatever the constitutional amendment mechanism is to get this on a ballot. Should this pass, a simple majority is sufficient a simple constitutional majority is sufficient to reject a particular regulation. And I believe that's in the mainstream of how other states have treated it, but we can double check on that if that would be helpful. Some of them might have a supermajority, I don't know.
That would be great. So just to clarify, so this would go on the ballot as a constitutional amendment, and the amendment would state, the way I'm reading it here, that if there was a regulation that was passed either by the executive branch or an agency of the executive branch, that the legislatures could override that with a 2/3 majority. Is that correct, or is it a simple majority? That's what I'm trying to understand.
Senator, that would be a simple constitutional majority, so 50% plus 1, 21 and 63.
Thank you for that clarification, and thank you, Madam Chair.
Yes, Senator Baumgardner.
Thank you, Madam Chair, and thank you, Attorney General, for being here today.
Senator?
Had this already been in place, had we already had this amending the Constitution, would we be in a different situation with regard to the recent executive order creating the Office of Child Advocate Division?
Senator, that's a tough question to answer, and I'll tell you why. I have some skepticism that the current executive order has the force and effect of law, that it has actual legal meaning. And if that is the case, that it doesn't, then this would not be relevant because this applies only to things that have actual legal meaning. I recognize there's a countervailing point of view on that, and so it's a little trickier than just a yes or no on that.
And Madam Chair, if I might, as a follow-up, I simply ask that question because there have been several press accounts where the governor has stated they'll have a tough time undoing this. And from that context, the executive branch is taking the position that it is law. So thank you very much.
Thanks, Senator.
Thank you. Committee, other questions for any of our conferees? Thank you, Attorney General. Seeing no other questions, I will then ask, are there any neutral or opponent conferees in the committee meeting room or online? Seeing none, I want to thank all of our proponent conferees and committee. We have heard this is a decades-long issue that needs to be addressed. It's both bipartisan in the relief that it seeks and in the issue that's arisen over the decades that we heard the history of from the Attorney General. So I want to thank him for his appearance and his testimony today, as well as our other conferees. With that, then, we will close the hearing on SCR 1618 and open the hearing on Senate Bill 457, requiring a waiver of extradition proceedings as a condition of bond. And with that, then, we will have a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. Back up here as usual on something a little different, more familiar to you possibly. We're in the Code of Criminal Procedure again with this bill. Senate Bill 457 deals with waiver of extradition proceedings as a condition of bond. We're looking at KSA 22-2802. That's the statute in our criminal procedure code that concerns release and conditions of release prior to trial. So this is before you've been tried and convicted, pre-trial release. The bill adds a new subsection C that you can find on page 2 of the bill, right about in the middle of the page, to provide that in addition to all the other conditions of release that are provided in the statute already, the magistrate shall order a person to execute a waiver of extradition that states the person consents to extradition to Kansas and waives all procedures related to that extradition if they're arrested in another state while on bond, and also acknowledging that the person shall not be released prior to trial in any other state pending extradition to Kansas. So these would be additional conditions the magistrate is required to put in when the person is seeking bond, and that's the policy choice you're being asked to make, whether that should be included in the statute as a requirement or left to current law where, permissive or allowing extradition to work as it normally does. So that's what the bill would do.
Thank you. Could you tell committee who requested this bill?
Sure.
Who was this brought to us by?
Right. Thank you, Madam Chair. You may recall this was requested by Greg Smith on behalf of the Johnson County Sheriff's Office, I believe, and he's here to testify. So I think you'll hear from them why this is a policy they're asking you to adopt.
Thank you. Committee questions for the reviser? Seeing none, then we will invite proponent conferee Greg Smith, Special Deputy Sheriff for Government, Veteran, and Crime Victim Affairs, Johnson County Sheriff's Office. Please introduce yourself and welcome back to committee.
Thank you, Madam Chair. I'm Greg Smith, Special Deputy for Government Affairs for Johnson County Sheriff's Office, and we did request this bill in this committee. Very simply, if you're charged with a felony in Kansas, this would require the judge to have you pre-sign your waiver of extradition so that you can be brought back to the state should you not be in the state of Kansas for your court date. The problem that we experience as a border jurisdiction is quite a few of the people that commit crimes in Johnson County live in Missouri. And they skip back over to their house in Missouri, and we can't get them back in Kansas without a long, protracted extradition process, which, if you're not familiar with that process, involves the agency that has charges against the fugitive, the local county or district attorney, the Kansas Attorney General's office, the Kansas Governor's office, the governor of the asylum state, the state where this person fled to, the Attorney General of the asylum state, the local prosecutor where the fugitive was apprehended, and the jurisdiction that has the Kansas fugitive in custody, as well as the court that has jurisdiction. All of these people are tied up now in hearings if someone refuses extradition back to the demanding state. Now, there are three things that control extradition. There's the federal constitution, the federal statute, and then there's something known as the UCEA, which is the Uniform Criminal Extradition Act. Federal statute and the Constitution set the outer limits. UCEA is somewhat of a more relaxed agreement between states, kind of an interstate compact type thing. 48 states belong to that. Missouri does not. So the problem we have is a lot of these persons charged with felonies are over in Missouri. To give you an example of what we dealt with last year, we had a total of 246 fugitive cases in Johnson County. 193 of those cases were in Missouri, and they all refused extradition. So this would simply put in place a policy where that person signs their extradition note, they can go back to their home in Missouri, and rather than have to go through this long protracted process of trying to get them back for court, the waiver's already signed so that we can deal with that. Now, there's one other thing that happens in a fugitive case in any state, not just Missouri. Fugitive leaves, the person leaves Kansas, they forget their court date, they purposely don't show up, whatever reason, they don't come to court. They get picked up in another state for a different charge in that state. This has nothing to do with the Kansas charge. Say it's a traffic stop. And when that officer makes a traffic stop, he does a wants and warrants check. Oh, you have a felony warrant out of Kansas. Picks that person up, takes them into jail. That person gets a hearing on the fugitive charge. They're being charged as a fugitive in the state they're in, but it's our charge now that we're dealing with. That judge can give them a bond on the fugitive charge, and they can bond out. And then we won't see them again. Now, the theory behind that is, sure, you can bond out, that way you can get back to Kansas and take care of your business. I can tell you from experience that does not happen very often. So that's the problem we're dealing with. That's why we asked for this bill, and I'm happy to stand for questions anytime.
Thank you. Committee, we do have proponent written testimony in your committee folder from Sheriff Jeffrey T. Easter, Legislative Chair, Kansas Sheriff's Association, and Steve Kearney, Executive Director, Kansas County and District Attorneys Association. So with that, we will open it up for questions for our conferee. Senator Wilborn.
Thank you, Madam Chair, and thank you, Deputy Smith, for being here. A question as it relates to Missouri. Who says that Missouri would honor even the waiver?
They may not. I mean, we can't predict what these other states are going to do, but we do feel that it will provide an avenue for them to be more cooperative. We actually took this language from Colorado. Colorado already has this in place. I can tell you, I'm also a former Kansas City, Missouri cop, and in my time when I was there in the late 90s, we would make a traffic stop on a car from Kansas, say, and that person has a warrant. And if the bond on the warrant was not over $5,000, we said, here's your ticket, have a nice day. Oh, by the way, you have a warrant in Kansas. So this is not a panacea. It's not going to fix everything, but we feel it would definitely help.
Thank you.
Thank you. Senator Haley.
Thank you, Madam Chair. Welcome back, Mr. Smith, to committee. Following up, what prohibits a judge now to make this a condition proceeding to bail? I mean, that that prior to bonding out, that they agree to waive extradition should they flee, especially where it's already shown that they are domiciled or that they're a resident of another state. Can't that already be one of the conditions met? Or is there some prohibition as to why that couldn't be done already by the judge, by the court?
Okay, and I apologize, Senator. My left hearing aid just went out, so I got about every other word.
And as you know, sir, for your years here on this committee, the acoustics in this old Supreme Court room aren't very good anyway. So why can't a judge already make a condition proceeding to bail or to bond out, I'm sorry, that they waive extradition? Why can that already be done prior to, especially where they're domiciled somewhere else?
Gotcha. Okay, yes. As a condition of bail, you heard the revisor say that a judge can put any reasonable restriction on someone that has a charge. Here's the issue. We discussed this with some of our judges in the 10th Judicial District. Their rationale behind this is, yes, technically under the law, we could use that clause, but we would be more comfortable if it was in statute.
Committee, other questions? Seeing none, then, thank you, Mr. Smith. Appreciate you coming to the Capitol today and providing testimony, and it's good to see you again back in committee.
Thank you, Madam Chair.
Thank you. Thank you for bringing this piece of legislation to committee as well. Committee, then, we are going to ask, are there any other proponent conferees in the committee meeting room or online? Do we have any neutral or opponent conferees in the committee meeting room or online? Seeing none, then we will close the hearing on Senate Bill 457 and open the hearing on Senate Bill 497. It's a long, short title, so I'll let the reviser talk about that. It is an issue that is important for the committee to look at. So with that, a bill brief from the reviser, Mr. Thompson.
All right, thank you again, Madam Chair. And yes, as you noted, our short titles are getting less and less short as we try to be more and more descriptive. So we hope it's beneficial, even though it's not as short. This is Senate Bill 497, and anticipating the question from before, this was requested in this committee by Bill Rowe on behalf of the Office of the Attorney General, and I see that the Attorney General is providing testimony as well, so they'll be able to talk about the policy behind it. This bill essentially does a couple things. It authorizes the Attorney General to coordinate training regarding a multidisciplinary team approach to intervention in reports involving alleged human trafficking for law enforcement agencies, and it requires training on human trafficking awareness and identification for certain child welfare agencies, juvenile justice agencies, mental health professionals, and school personnel. So we're in KSA 75-756, which is in the Attorney General's group of statutes in that Article 7 of Chapter 75. It currently authorizes the Attorney General to coordinate training regarding human trafficking for law enforcement agencies throughout Kansas. So you enacted this a few years ago, and the Attorney General is doing this currently for law enforcement. The new subsection A would add a public policy statement to say that it is the public policy of the state that law enforcement agencies shall implement a coordinated multidisciplinary team approach to intervention in reports involving alleged human trafficking, as well as aggravated human trafficking and commercial sexual exploitation of a child, which we've kind of come to use all three of those terms together in our statutes as a bundle of issues that should be addressed in the same sort of manner. Subsection B would amend that current law that requires that allows the Attorney General to coordinate training to direct that more specifically to be training on a multidisciplinary team approach, which I understand is a term used in the field and has a very specific meaning that the Attorney General's office can explain to you what that would mean and how they're already doing some of that. But it would be a more specific and multidisciplinary approach to that training. And then finally, subsection C would be the new piece of law that I think you've seen a lot of testimony on and is maybe expanded on a little bit in the fiscal note in a way that I'll reference now because that's not something I normally would do, but I think it's necessary here because it expands on kind of how this might be done. But this subsection would say that in each fiscal year, this list of persons would be required to complete 1 hour of training on human trafficking awareness and identification. And that training would be approved or developed by the Attorney General's office. The list includes, and I briefly described it in the bill brief, but it's a fairly substantial list in the bill. Employees or contractors of several agencies who in the course of their employment have regular contact with members of the general public, certain licensed mental health professionals and counselors, all teachers, school administrators, and employees of educational institutions, and all persons licensed by the Secretary of Health and Environment to provide child care services and the employees of such licensees. So obviously a lot of folks that have interaction with children and others who might be at risk of human trafficking. The fiscal note I will point your attention to as well and defer obviously the Attorney General's office indicates that this training requirement would be implemented by the Attorney General as an online option. They would develop the training program. They would offer it online free of charge. And with that caveat, it looks like that would be how it's delivered. It's not specified in the bill. I just wanted to be clear about that. But we do have some more information about how it might work in the real world, that they would develop and approve this program and roll it out for all of these folks to take that 1 hour of training. So I think that's it for me. I'll see if you have any questions and hopefully let the conferees explain to you a little bit more about the policy.
Thank you. Mr. Thompson, was this brought to us by the Office of Attorney General?
Yes, Madam Chair, and I apologize. I mentioned at the very beginning when you were having a sidebar, but
okay, I'm sorry.
That's all right. I understand. We're all very busy right now.
Thank you. Committee, any questions for the reviser? Seeing none, then we will ask each of our 5 proponent conferees to limit their testimony to 4 minutes in the interest of getting out of committee on time for other meetings of our committee members. And I'll give you a 1-minute warning if if that will help. So with that then, we'll invite Michelle McCormick, Director of Victim Services, State of Kansas, Office of the Attorney General, to the podium. Please introduce yourself and welcome to committee.
Good morning, committee. Thank you for having me, Madam Chair and members of the committee. I am Michelle McCormick. I'm the Director of Victim Services for the Kansas Attorney General's Office and serve as the State Victim Rights Coordinator. I also, in my capacity, chair the Victim Services Subcommittee of the State Anti-Trafficking Advisory Board. But prior to that, I want you to know I worked at a private nonprofit where we served victims of human trafficking directly, and my colleagues here in Topeka served hundreds of victims of trafficking right here in Topeka, and most of those victims residing here in Topeka. And so I, in my 4 minutes, want to share with you, you have my written testimony, of course, but I want to share with you that first of all, I want to say I'm very proud of the great strides that the state of Kansas has made in the last 10 years on the issue of human trafficking, but there is still work to do. We still have vulnerable Kansans who are being exploited in both labor and sex trafficking, and so we have some more work to do. And one of the challenges that we've experienced in the last several years is really some misinformation out there about what human trafficking actually looks like here in Kansas. And so we bring this to you today really as we think a good step in the right direction of getting folks who exist in that multidisciplinary response some standardized basic training. We really think that we know from experts in the field that the multidisciplinary response to this issue is the most effective way to get to our goal of ending human trafficking. But we really need to create this base of shared understanding about what those risk factors are, what those key indicators are. And so we think that this bill will take a step in the direction of creating that shared knowledge base so that folks across those disciplines are speaking the same language about how we can best intervene in trafficking. You'll note that the focus of the folks in this bill primarily are those who are already deemed mandatory reporters, and we think they have a really strong opportunity to identify trafficking and help us start the interventions appropriately. I'll just say that about 10 years ago was the first time I got training from the Office of the Attorney General in human trafficking. And even though I've been in the victim services field for, 20 plus years, that experience really ripped the blinders off for me professionally about how human trafficking is existing here in our state. And so I've been really committed to ending that kind of exploitation ever since. And I think that our colleagues want to join us in this effort, and we think this is a nice vehicle in order to get us to the next stage of great progress in the state of Kansas. So thank you for allowing me to share those thoughts today, and we'll stand for questions at the appropriate time.
Thank you. And committee, we will hold all questions until we've heard from all our conferees. With that, then, we will invite Sharon Sullivan, PhD, on behalf of the Human Trafficking Advisory Board Awareness, Prevention, and Education. Please introduce yourself and welcome to committee.
Thank you very much. Good morning, everyone. I'm Dr. Sharon Sullivan. I am here to testify on behalf of HTAB, the Human Trafficking Advisory Board for the state of Kansas, and the HTAB Awareness, Prevention, and Education Committee. I am also an educator and an advocate. I've spent nearly 20 years addressing human trafficking in Kansas in a variety of ways. Let me be clear, human trafficking is happening here. It is happening in our rural communities, in our big cities, in our schools and homes, in our neighborhoods and businesses. The victims are Kansans. Our neighbors, our coworkers, our children. It is a horrific life that most of us can't even imagine. For a lot of complex reasons, very few victims self-identify or ask for help. All are under the control of a trafficker who uses force, fraud, and coercion to control the exploited person. They do not have the freedom to leave the situation. Too many times we see this crime ignored or worse, mischaracterized due to a lack of accurate information. Education and training of professionals who regularly encounter vulnerable people is crucial to prevent victimization of people who have already been victimized by this crime. At a minimum, these professionals should include law enforcement, juvenile justice professionals, healthcare fields, and anyone working with children, among others listed in the bill. This is a very complex crime. No one will become an expert in a one-hour training. However, participants can learn to identify signs of human trafficking and how to respond appropriately. This can be life-changing for a person trapped in human trafficking. Additionally, these trainings build on the existing knowledge and expertise of each profession. Many agencies, including the Attorney General's office, have worked diligently to provide trainings to professionals in Kansas. But we need comprehensive and ongoing training now, and this can best be achieved through legislation. Too many times, victims are identified only because a trained professional noticed a red flag and knew who to call. The safety of our most vulnerable Kansans depends on more professionals recognizing their victimization and taking action. Please empower them to do so. Please pass Senate Bill 497. Thank you.
Thank you. Next, we will hear from Ferone Barr, past Director, Governor, and Representative, Rotary International District 5710. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and committee, for welcoming me here today. I'm a representative of District 5710, Ferone Barr. I'm immediate past district governor, and we have 44 clubs in Northeast Kansas, encompassing about 2,100 Rotarians that have really focused on the cause of eradicating human trafficking. We started this in 2019 when we started realizing how prevalent it was in the state of Kansas, and so we need to do something. Since then, we have discovered ways in which our members can be involved in bringing awareness to what human trafficking looks like in this state, also helping with victim aid and reintegration, and also legislation advocacy as well, and education of various people throughout the state on what human trafficking really is. In 2019, we partnered with a Rotary District in Mumbai, India, to provide a grant that funded a day center through the YWCA to help human trafficking victims that were still in the life. My wife volunteers for this day center, and since November of 2019, they have seen 485 separate victims come through this day center. That's just in Topeka. Our district has been involved in several grants that have brought in funds from a variety of sources to help communities in Topeka, Manhattan, and Kansas City, and we're looking for other areas to help as well. Throughout a worldwide network, we have partnered with clubs and districts from India, Panama, Taiwan, and South Africa to bring in over $200,000 in grant funds to help with human trafficking efforts. One area that has been identified that is very important aspect of preventing human trafficking is education of people who might see potential victims. We feel that requiring education of the professions mentioned in SB 497 is a much needed law and will help reduce the occurrence of human trafficking. In 2017, California enacted AB 1227. That is another law very much like this that it requires 2 hours of mandatory training for school personnel. The Rotary districts and clubs in California have partnered with the AG's office there to provide training to thousands and thousands of educators throughout the state of California. And we see that this could happen here as well with Rotary's help. Our district and District 5680, which is South and Western Kansas, have partnered several times on different projects, and one of the ones we just partnered with was on the mandatory hotline posting law that just got enacted last year.
1 minute. 1 minute.
Okay. And so we see that this is going to be an area where we could partner again to try to help push this out and educate as many people as possible. We hope you support SB 497, and I'll be available for questions afterwards if time allows.
Thank you. Next, we will hear from Usha Reddy, President, Rotary Club of Community Action Against Human Trafficking. Please introduce yourself and welcome to committee.
Good morning. My name is Usha Reddy. I'm coming from Manhattan, Kansas, and I'm president of the Rotary Club of Community Action Against Human Trafficking, or CAT Club for short. We are focused and dedicated completely to eradicating human trafficking. And on behalf of the Rotary Club of Community Action Against Human Trafficking, we support Senate Bill 497 legislation for requiring training on human trafficking awareness and identification in coordination with the Attorney General's office. Our club is dedicated and committed to putting an end to human trafficking. We do this through advocacy, legislation, education, prevention, and providing resources and support for victims, survivors, their families here and abroad. Our projects, initiatives, speaker programs, and grants emphasize a call to action. We assist survivors, but we must work relentlessly to put an end to stop human trafficking. A large segment of the population does not recognize that human trafficking is taking place in their backyard. It happens in our schools, homes, workplace, and other sectors of daily life. Many are not sure how to identify signs of a child being trafficked. While we work with community organizations and government agencies to provide awareness and education, it is essential to implement legislation to require training for professionals that work with vulnerable populations and minors. This will move the needle to recognizing and reporting human trafficking more than anything else. We hear many stories of boys and girls groomed by individuals to use them for trafficking and sexual exploitation. It's time to empower professionals with knowledge and skills to work together to help children get out of these traumatic situations. Senate Bill 497 will have a major impact on our families, communities, and society by not only bringing attention to human trafficking, but making it a priority. This is a right step in the right direction, to putting an end to human trafficking and keeping our children safe. Rotary Club of Community Action Against Human Trafficking supports SB 497, and we look forward to working and doing our part to working with you and community organizations and agencies to implement this legislation. And I say that because we are also working with the Attorney General's office to distribute posters for the 1-800 hotline number. We are working with so many agencies across the state because it is so important to us. 1 hour of training may not seem enough, but it is more than what we have now, and we need to make sure everybody has the resources and knowledge to recognize skills and how to report it within our agencies. Thank you.
Thank you. Next, we will hear from Philip Cosby, State Director, American Family Action of Kansas and Missouri. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Philip Cosby, American Family Action. For the past 20 years, I have spoken mostly in Kansas on the subject of promotion of obscenity, materials harmful to minors, child pornography, human trafficking, internet issues, and this sits squarely, of course, I support this widespread education. And I did support when the Attorney General introduced Senate Bill 61 on human trafficking, where he made the nexus and the connection of strip clubs and human trafficking. If we were to ignore that strategic point, not just education, but enforcement and recognizing some of the issues where this emerges from, strip clubs are a big part of that. And in his statement, he says, not limited to mitigate the adverse secondary effects of sexually oriented businesses. You have in this committee right now Senate Bill 352. It is called the Community Defense.
Mr. Cosby, the subject of the testimony today is Senate Bill 497.
Got it.
Thank you.
I'm only here to propose upon working in the appropriate time that you look in your folders and realize that there is a golden opportunity to match education and enforcement. There is this bill Community Defense Act, which will dovetail perfectly. It is a golden opportunity that these two are merged and shown that not just awareness, but teeth are put into this one area as well. This is not, the evidence of harm is not anecdotal as far as human trafficking goes. The courts from the Supreme Court, every appellate court that has dealt with restrictions on these businesses has held it.
Mr. Cosby, you're going to have to keep your testimony to the bill that we are currently hearing, which is Senate Bill 497.
Thank you, ma'am. Human trafficking. The restrictions that do exist are constitutional and reasonable and address human trafficking as a negative secondary effect. There are many other negative secondary effects, but human trafficking, and I did supply 2 news stories, one out of Wichita and one recently about human trafficking and the nexus with the existence of these businesses. So I'm not...
Mr. Cosby, that's your 3rd warning, so we're going to end your testimony if you're not testifying about Senate Bill 497.
I am testifying about human trafficking.
Let's keep it on the bill.
I support this bill as educational. When you do work it, I hope you would consider an amendment to also include the wider scope of human trafficking and these sex businesses. Thank you.
Thank you. Committee, we do have electronic copies of proponent testimony. We do not yet have written copies in your committee folder from Ms. Sullivan, Mr. Barr, Ms. Reddy, or Mr. Cosby. So we need those conferees to please provide those written copies today. Those were to be turned in ahead of time. We will then invite our proponent conferee who's appearing via WebEx, Ashley S. Chapman, JD, founder, CEO of Engage Together. Please introduce yourself and welcome to committee.
Thank you so much, Madam Chair and committee members. My name is Ashley Chapman. I've had the joy of working to help Kansas address human trafficking issues for about the last decade now, working alongside many of the folks that you've heard from already today and many, many others. The importance of today's hearing on SB 47, I just cannot overstate. Its fate determines the fates of hundreds, maybe thousands of lives in the state of Kansas. As a human rights lawyer and justice advocate, I've spent the last 20+ years helping communities end and prevent human trafficking all around the world, across the US, and across the state of Kansas too. What I know to be true is that human trafficking is happening in nearly every community in our nation today. Kansas is no exception. It is a known fact that both labor and sex trafficking of adults and minors, foreign nationals and citizens, are occurring in the communities across Kansas. Urban, rural, large, or small, no community is immune. But it is also true that all those in a position to recognize and respond to human trafficking have not yet received the training they need to successfully do so. That's why this bill is critical. Its passage will save lives. If it fails to pass, lives will be lost. Creating a law in the state of Kansas that mandates key community stakeholders receive training on human trafficking will increase identification, care, and outcomes for survivors. I've seen it happen time and time again. And the key professions that need to receive training in every community in your state include, at a minimum, educators and school personnel, behavioral health providers, healthcare professionals, group home, foster care and adoptive families and associations, juvenile justice professionals, community advocates and organizations working with at-risk or high-risk populations, case managers, and really all of those working in child welfare. Each of these individuals in your communities are uniquely positioned to recognize human trafficking indicators, but they will also need each other to successfully respond. Mandatory trainings then help to create both a systemic and system-wide approach to addressing human trafficking in each of your communities and across your state. And given that these professions especially experience high turnover rates, mandatory training will make sure that the next professional to carry the baton forward doesn't miss a beat in knowing what they need to know to keep individuals safe. From my seat, this bill should be the easiest yes on your docket today. Human trafficking knows no bounds. It is often hidden in plain sight. It is many times the culmination of compounding vulnerabilities in individuals' lives, and its presence in your communities is the worst of consequences of really many issues that still need to be better addressed. But that work begins by equipping those in a position to see it. So I implore you today, pass this bill, mandate these trainings, and make sure that those in need of the trainings also have the resources available to them to implement it. Thank you.
Thank you. Committee, in your committee folder, we do have proponent written testimony from Ed Klump, Legislative Liaison, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association, and also proponent testimony from Shanna Jager, Executive Director of Public Policy, Children's Alliance of Kansas. With that, then, if we don't have any other proponent conferees in the committee meeting room or online, if there are any, speak up. Seeing none, then we will open it up for questions. Yes, Senator Haley.
Madam Chair, thank you. I'll be brief. The hour is upon us. I'm appreciative of the proponent testimony, and let me also first publicly acknowledge my appreciation for the Attorney General, Derek Schmidt, who both in the State Senate, a member of this committee, and now, of course, as Attorney General, has been one of the early advocates of recognizing human trafficking as a growing social disorder and has been effective in working towards bringing about meaningful change. When we go to truck stops, for example, now in Kansas, and we're seeing that we're asking those to be vigilant and aware of what's going on around us, I look and give recognition to his efforts to make that so, and many other examples. This Bill 497 sounds great to me, and it seems like something we can do, Madam Chair. I guess my question is, as they say, the devil's in the details, that were it to pass, do any of the proponents quickly suggest how it's implemented for the hour? We know who the stakeholders are, we know who the mandatory reporters would be, but what does that look like for that 1 hour? Is there an annual checklist, or would it be, I know you're not going to have a conference, you can't, of everyone that would be required, so how do you implement this so it's consistently providing seamless awareness and implementation of through this training for all of those that we expect? And I know no one may have the answer to that question right off, but that's certainly something I'd like to see implemented and maybe even made a part of the bill so there's uniformity in implementation.
Ms. McCormick, you look like you'd like to address the question. Please reintroduce yourself. Thank you.
Thank you, Senator Haley, for your question. I'm Michelle McCormick, the Director of Victim Services at the Kansas Attorney General's Office. And although we haven't worked out all of the complete details yet, Senator Haley, it's our intention, as the revisor stated, to complete an online training module that would address the red flag indicators and sort of cover that basic identification information so that all of the folks identified in the bill were getting that standard sort of information, which of course will be based on the best research that we have available at our office. And so that's our intention, is that they would complete the training and then get some sort of a certification, whether it's a certificate or an electronic acknowledgement that they did in fact complete the training. And so I'm not sure if that answers your question, but that's our intention of how we would address some of the detail of that.
Again, Madam Chair, to answer it, I just would like to see something. I mean, you mentioned the Colorado or other models, how effective it's been in how they're actually making it work. You know, going through this whole process and procedures, and at the end of the day, we don't have what we plan, always concerns me. And I'd like to just kind of get the nuts and bolts together as we move this through the process. So we have an effective training module presented, if not in statute and rules and regs, so that we have it really hit the ground running and be effective.
Yeah, I appreciate that feedback, and certainly I think we share that goal. So thank you.
Thank you. Senator Baumgardner.
Thank you, Madam Chair. And first want to say thank you to Ursula Reddy for mentioning a very important term, grooming. Because grooming is actually one of the most, I think, defining telltale things for people to watch out for. And, you know, it's interesting, we have 5 members of this committee that represent parts of Johnson County. And there happen to be 2, I would say, hot spots for grooming in Johnson County. And it's right where Gardner, Spring Hill, and Olathe intersect. And that's where 2 adult entertainment buildings are. We know them as strip clubs. They happen to be in my Senate district. And what they are doing is they are grooming students from Gardner, Spring Hill, and Olathe. So I appreciate that that term was brought up. Michelle, if you could please share with the committee, because I've had the privilege to work with you on a different committee and have benefited from the wealth of your knowledge and understanding. Could you please share with the committee and those that are watching the age ranges that you have seen in Kansas of individuals that have been human trafficked?
Ms. McCormick, please introduce yourself again. Thank you.
Michelle McCormick, Director of Victim Services at the Kansas Attorney General's Office. And thank you, Senator, for your question. I can tell you, so the bulk of my personal experience of working with victims and survivors is mostly serving adults. And the age range has, of course, been 18 through people who I would say in their late 60s. I do know, though, from our multidisciplinary work at the State Anti-Human Trafficking Advisory Board, that my colleagues who work in child welfare have absolutely worked with victims who are in the age range of 11, 12, very young victims. And so unfortunately, sex and labor trafficking affects folks really across the lifespan. There are folks who are at risk of being trafficked.
Okay, thank you. And I guess the reason I bring this up, and this dovetails on what the Senator Haley had brought up. You know, several years ago, we passed the Jason Flatt Act so that all school employees were to have the 1 hour or the 2 hour training on suicide prevention. And what we found is we had lots of school districts that weren't making sure that that was happening. And so to me, we're talking about kids that potentially are grade school, but definitely middle school and high school. So it is going to be very crucial that we make sure, particularly that the school districts are enforcing. So I think it's important that not so much that we can legislate in this, but we do come up with a process so that there is that accountability. Thank you, Madam Chair, and thank you, Michelle.
Thank you. Committee, other questions? Senator Corson.
Thank you, Madam Chair. I really appreciate all the proponent testimony. Probably this is for Michelle, but for folks who are listed in C1, 2, and 3 who have some sort of a license, would this 1 hour requirement be an additional requirement for maintaining their license, or would this be part of a continuing education requirement that various professionals have? You know, and would you envision, you know, taking action against licensed folks if they fail to complete this 1 hour? Can you just talk a little bit about that aspect with respect to any of these folks who have a professional license they hold and need to maintain?
Make sure you introduce yourself again. Thank you.
Thank you for your question, Senator. Michelle McCormick, Director of Victim Services, Kansas Attorney General's Office. I think, Senator, the way we were envisioning it is that those current licensees, in particular the BSRB licensees, already there are some requirements set out for licensure. So for example, I'm a licensed master's level social worker, and I'm required to get 6 hours of diagnosis and treatment, 3 hours of ethics every couple of years in order to maintain my license. And so our intention would be is that one of the total 40 hours that I'm required to get, one of those hours would need to be on human trafficking identification and awareness.
Is the thought then that that you would work then with the licensing agencies to make this a part of the license requirement, and that would be further action needed on behalf of the legislature to make that happen, or what are the thoughts there?
It's a great question, Senator. I think that we were just envisioning that they have to get 40 hours anyway, which is already spelled out, or the individual licensees, it's already spelled out what their total hours of training, continuing education is already spelled out, and that this would give it the opportunity of one of those hours would be designated for human trafficking.
Thank you. Committee, other questions? Seeing none, then are there, oh, I'm sorry, Senator Bowers.
Thank you, Chairwoman Warren. No question, just a comment, just to say I'm just so delighted to see Rotary International testifying on this bill. You know, we've been established as a Rotarian from District 5680, you know, known for eradicating polio, clean water across the world, reading literacy for our children, and now to be progressive and modern to find human trafficking that we can work on as a problem that we all recognize. So I'm very proud of our Rotary clubs that have stepped up to do this in our district. So I just want to make that comment. And maybe there's Rotarians on this committee also. Sorry, I have a sore throat, but thank you for letting me make that comment.
Thank you, and I think Mr. Barr is from my area of the state, so thank you for coming to the Capitol today, and thank you for all of our conferees. Are there other questions for the conferees? Seeing none, then we will ask, are there any neutral or opponent conferees in the committee meeting room or online? Seeing none, then again want to thank all of our conferees for appearing today in your testimony, and we will close then the hearing on Senate Bill 497. And before we adjourn, we have a point of personal privilege from Senator Wilborn.
Thank you, Madam Chair. You've had a full plate today. I'd like to introduce Caleb Stout. He's from Chase County, a constituent of mine. He's going to shadow me today, and he's a junior at K-State. Stand up, Caleb.
Welcome to committee, Caleb. Well, committee, we do have a committee meeting tomorrow. We will have to watch the weather. I understand that there is some ice and snow coming maybe around 2, 3, 4 a.m. So please, if we are able to distribute to our usual distribution list of agenda, folks who receive the agenda, we will try to get that message out. But please be watching your email, and we will try to communicate as best we can. We want folks to travel safely and to be cognizant of that. So with that, committee, then I will thank you for your time and those who are following along online in the committee meeting room, and we are adjourned.